6:47 a.m., my phone flashed a message from my business partner. "We need to discuss something urgent. Your wife has asked me to fabricate testimony in court." As I read those words, my wife Brielle hummed in the shower, seemingly oblivious to the divorce papers she thought I was unaware of. Unbeknownst to her, I had been anticipating this for the past 4 months. I am Connor Ashford, and this is an account of how my wife attempted to stage a surprise divorce ambush, only to have her own strategy turned against her, a tale spanning 18 years. It was 18 years since Brielle and I had been married, during which we constructed what I believed was a secure life, a thriving consulting firm I'd nurtured from the ground up, a suburban home, 2 golden retrievers, and a marriage I thought was steady if not passionate. However, the first fissure emerged 9 months prior to that fateful text. Brielle declared her intention to enroll in an expensive wellness program. 3 times a week for yoga weekend meditation retreats were scheduled. A life coach costing $300 per session was hired. I approved as she seemed happier, more energized. I was often away on work trips expanding the client base in the Southeast. Our business was flourishing, allowing us to prioritize her self-care regimen. However, financial inconsistencies arose. I'm diligent with our accounts. Every quarter I scrutinize our household finances along with the business records, a practice from my past running the firm on tight budgets. In November, I discovered an anomaly, $4,200 taken from our joint savings marked as a wellness retreat deposit. I questioned Brielle about it during dinner. "Ah, that's for the February intensive in Sedona," she replied offhandedly, not looking up from her phone. Hadn't I mentioned it? She hadn't, but I chose to overlook it. Trust is vital in relationships, isn't it? Then, another withdrawal occurred in December, $3,800. "Holiday booking fees," she clarified, "were not specific." Unexpectedly, the third withdrawal in January amounted to $5,500 without any explanation whatsoever since I hadn't inquired. Instead of confronting the issue, I opted for a different approach. I established a separate checking account and began meticulously recording all transactions. This included withdrawals from our shared accounts, credit card charges under her name, as well as Venmo transactions that could be traced. I wasn't assuming any wrongdoing at this point. I was simply cataloging. The pattern that unfolded left me feeling sick to my stomach. For half a year, Brielle shifted $47,300 from our joint accounts. These withdrawals were tactically timed, never reaching the level to set off bank alerts and always accompanied by justifiable reasons, such as wellness programs, home renovations we had discussed, or gifts for her mother. However, when I compared her calendar with the charges, there was no correspondence. The $2,400 charge at a luxurious hotel in Charleston occurred on a weekend she claimed she was visiting her sister in Atlanta. $850 monthly payment to Meridian Consulting Group had no business connection I could find. A $6,200 transfer to an account labeled BT Holdings didn't make sense to me, considering my association with BT, Brielle, and someone else unidentified. That was when I decided to hire a forensic accountant. Gerald Moss, suggested by a college friend who had experienced a contentious divorce, came highly recommended. In his 60s and with a thick Boston accent, he possessed the diligent enthusiasm of a man who passionately sought hidden finances. "Firstly," Gerald stated during our initial meeting, "I must know if you desire truth or comfort." "Truth," I responded instantly. "Well, as most of the clients who employ me dismiss me when I uncover what they prefer, I wouldn't," he warned. He didn't sugarcoat it. Within 3 weeks, Gerald followed Brielle's financial trail she believed she had concealed. The $47,300 was merely the tip of the iceberg. She had applied for a credit card using her maiden name, which she could do since we kept separate credit records by choice. The card revealed an additional $23,000 worth of charges on flights, hotels, restaurants, in cities where she claimed solitude during wellness retreats. However, the troubling revelation was the property acquisition. BT Holdings, contrary to being a consulting firm, was a Delaware-registered limited liability company, co-owned by Brielle Ashford and Troy Patterson. It turned out that Troy Patterson, my 12-year business partner, had used the LLC to purchase a vacation condo in Asheville, North Carolina, for $185,000 with a down payment of $55,000. The funds for this purchase were sourced from marital assets systematically diverted by Brielle and supplemented by Troy's capital contribution. As I sat in Gerald's office, he clarified the legal implications, stating plainly, She has been committing financial fraud. This isn't about personal expenses. She used marital funds to purchase property with a third party without your knowledge or consent. You're dissipating marital assets. A competent divorce lawyer would use this against her severely. Instead of feeling angry, I felt unusually calm. Can you compile all the details in a court-approved format? I requested. That's my specialty, Gerald responded. I will do it then. I require a comprehensive forensic report. Every transaction must be traced, every asset identified, and the evidence should be watertight. Are you plotting something? I'm just preparing myself. The next move was to ascertain the affair itself. While financial fraud was concerning, I needed proof that Troy and Brielle were romantically involved beyond business dealings. I couldn't accuse them based on property records alone and expect a confession. So I hired a private investigator, though it felt intrusive and paranoid. But Gerald was correct. I needed the truth, not speculation. The investigator, Kimberly with 2 decades in law enforcement, simplified the process. Provide me 3 weeks, she requested. Should there be a discovery, I'll uncover it. She managed it in 8 days, the proof being unequivocal and distressing. Brielle and Troy, seen at restaurants in Charlotte, his hand on her lower back. They were detected entering the Asheville condo together on a Wednesday afternoon when Brielle had informed me she was attending a day spa retreat. A weekend getaway to Savannah where they occupied the same hotel room. Kimberly's report included timestamps, GPS data from Brielle's phone location history, something I'd never thought to scrutinize because I trusted her, along with receipts showing shared usage of a joint credit card under the BT Holdings account. This is classic, Kimberly concluded. They've been careless. Affair partners often become less cautious once their initial apprehension subsides and they grow comfortable. I thanked her, settled her final bill, and returned home for dinner with my wife as if nothing was amiss. For 6 weeks, I led a dual existence. By day, I operated the consulting firm with Troy, maintaining an outward semblance of normalcy as we discussed client strategies, scrutinized quarterly forecasts, and shared meals twice weekly. She made no reference to Asheville, nor displayed any signs of remorse. During the night, I returned home to Brielle, who immersed herself wholeheartedly in her wellness journey, attending numerous yoga sessions and weekend retreats. Her spirit seemed lighter, happier. She radiated a luminous quality that one often associates with those infatuated by fresh love and the exhilaration of deceit. I played my part flawlessly while secretly planning ahead. I arranged meetings with Dalton Reeves, a divorce attorney known for his assertive litigation style, which left other lawyers apprehensive. I disclosed all evidence to him: Gerald's forensic report, Kimberly's surveillance data, financial records, property deeds, images. Upon seeing the material, Dalton leaned back in his chair and let out a low whistle. "This is the most straightforward dissipation case I've encountered in 5 years," he commented. "She gave you the means for her own downfall on a silver platter." I questioned. "What's the plan?" they responded. "We initiate first swiftly. We instantly freeze the joint accounts, seek immediate emergency relief to prevent any further depletion of assets. We file civil fraud charges against her and Troy. Let them both feel it. However, my intention isn't to cause her pain out of spite," I clarified. "I desire justice. Justice will undoubtedly bring pain," Dalton remarked. "Believe me." Furthermore, I took a step Brielle hadn't foreseen. I vacated the house, not in some dramatic late-night exit with bags and accusations. Instead, I found a temporary business rental near the office. Over a 3-week period, I discreetly transferred essential items: my wardrobe, personal documents, my grandfather's watch collection, albums from my childhood, items of significance. I left behind everything Brielle would notice, such as my laptop in the home office, my half-filled closet, and my car parked in the driveway most evenings. I ensured she saw me coming and going at usual hours. 4 nights weekly, I used the rental as my base, citing late client engagements and early business presentations. She didn't inquire further. Instead, she was occupied with Troy. The rental transformed into my operational hub. It was here that I conferred with Dalton, scrutinizing final documents and strategizing for upcoming events. I also managed finances meticulously, lawfully shifting my business capital into a distinct account, which belonged to me based on the firm's earnings. Each transaction was noted with details stating it served business purposes, not matrimonial resources. I fortified our shared business accounts, imposing stringent authorization prerequisites for Troy's approval in significant transactions. I wasn't concealing assets. I was safeguarding what legally belonged to me, while she persisted in misappropriating what didn't belong to her. The day Troy messaged about Brielle demanding he falsify court testimonies, The pace quickened. I promptly contacted Dalton. "I'm about to submit the paperwork," I stated. "We'll file today itself," Dalton replied. "Meet me at your office in an hour." By midday, we submitted a divorce filing. This was not a basic dissolution. Instead, it included a detailed motion for emergency relief, which requested 1. Immediate freezing of all joint accounts. 2. A temporary order prohibiting Brielle from accessing or selling marital assets. 3. A forensic accounting review to be presented as evidence. 4. Complete disclosure of all assets, including the Asheville property. 5. A civil fraud claim for reimbursement of misused funds. 6. The guilty party to cover legal fees. And 7. We also filed a separate civil suit against Troy for interference and fraud. The documents were delivered in the afternoon when Brielle was at yoga. I wasn't present during the service. Based on the timestamp on the service confirmation, she was served at 4:47 p.m. outside a downtown Charleston boutique hotel, the same place Kimberly's report stated she'd been 3 times previously. My phone began ringing at 5:02 p.m., displaying Brielle's name repeatedly for 15 consecutive calls, which I chose not to answer. Dalton had emphasized no personal contact until papers were served. She left voicemails, messages I did not listen to, and texts. One message read, "Connor, what the hell is this? Call me now." Another said, "This is insane. You're freezing me out of my own money." "Then you can't do this. My lawyer says this is harassment," was another. I replied only once, following Dalton's instructions. All communication should be made through attorney Dalton Reeves. His contact details are provided in the filing. She called 17 more times that night. I switched off my phone and slept soundly for the first time in months. 8 days after the initial hearing, the gravity of my actions became evident to Brielle, not for me but for her. She discovered that our joint accounts were in fact frozen, and she was unable to use the credit cards or touch our investment funds. The mortgage and utilities payments were being made from an escrow account I had established via Dalton, yet she could not access any liquid cash beyond what was in her personal checking account. On the 3rd day, she appeared at my office. Security informed me that she was waiting in the lobby, demanding to speak with me. I replied calmly that I was unavailable and recorded her visit. Over the following days, she sent emails filled with confusion, shifting from questioning, "Why are you doing this?" to expressing anger about being punished for seeking space, eventually reaching a state of desperation, pleading, "Can we discuss this like adults?" I forwarded every email to Dalton without responding. Meanwhile, Troy had already obtained legal representation. In response to the attorney's letter asserting a baseless civil claim, Dalton issued a detailed 3-page reply, complete with evidence and financial records. Troy's lawyer fell silent after this. The courtroom on the day of hearing was smaller than anticipated, featuring wood paneling, fluorescent lights, and Judge Evelyn Carver reviewing papers with reading glasses. Brielle arrived accompanied by Hugh Preston, a well-known attorney from aggressive family law practice. He exuded confidence, suggesting he was not fully informed, while Dalton and I sat at our table laden with documentation. Gerald Moss waited in the gallery to testify if required, and Judge Carver initiated the proceedings. "Today we address emergency relief motions for Ashford v. Ashford," she declared. "Mr. Reeves, you have filed your request." Dalton then stood to speak. He did not resort to grandstanding. In a straightforward manner, he presented the details. "Your Honor, this case involves a series of financial irregularities by the defendant over a span of 18 months. Our forensic accounting evidence demonstrates that the defendant withdrew $47,300 directly from marital accounts and incurred an additional $23,000 in undisclosed credit card debt. These funds were utilized to buy real estate, specifically a condominium in Asheville, North Carolina, with a third party, Mr. Troy Patterson, whom the defendant was associating with. It is also relevant that this partnership occurred during an extramarital affair." "Objection, Your Honor," interjected Hugh Preston abruptly. "These accusations are inflammatory without—" "Mr. Preston, please take your seat," Judge Carver ordered without looking up. "You'll have your chance to respond," Mr. Reeves continues, pulling out the property deed and distributing copies to the judge and opposing counsel. "The real estate was purchased through an LLC named BT Holdings, registered in Delaware. The defendant co-owns this LLC with Mr. Patterson. The initial payment for the down payment was sourced from joint marital funds. It was presented that the respondent secretly opened credit accounts without her husband's knowledge, lied about her whereabouts to hide an affair, and transferred money to sustain a separate lifestyle with her lover. Gerald's forensic report was put on the table, detailing 63 pages of transactions and lies. The request to the court includes freezing all joint assets until a complete financial disclosure is provided, requiring the respondent to do so, and granting temporary possession of the marital home to my client. Additionally, reimbursement for wasted assets and attorney fees are being sought. Judge Carver directed this at Hugh Preston. What is your response? However, Hugh, now appearing less confident, asked the court, Your Honor, does my client admit to making a business investment with Mr. Patterson? Yes, but labeling this as fraud requires that Mr. Ashford was aware of this investment. Judge Carver then interjected. Did the funds used for the investment come from marital resources? But my question is different. Was Mr. Ashford informed and did he consent? There was no response. No, Your Honor, Hugh eventually admitted. Judge Carver put down her glasses. So your client took marital funds, bought property with a third party, hid the purchase from his spouse, and you argue this isn't dissipation. I see the circumstances are more intricate, I assume. Judge Carver focused on Brielle. Brielle, please stand up. Brielle stood, looking smaller than before. Her hands were trembling. Did you buy property in Asheville without your husband's knowledge? Yes, but did you use marital funds for the purchase? Brielle looked at Hugh, who gave her a barely noticeable nod. Yes, she whispered. Were you involved romantically with Mr. Patterson during your marriage? Another longer pause. Yes, the word lingered in the room like fog. Judge Carver adjusted her spectacles and penned down notes. A prolonged quietness filled the room for approximately 30 seconds. I'll deliver my verdict now, she announced. The joint accounts shall remain frozen until a comprehensive financial disclosure is made. Mrs. Ashford, you must submit full financial details within 2 weeks, including bank statements, credit card records, tax returns from the past 3 years, documentation regarding LLC formation and the specifics of property purchases. Mr. Ashford will be granted sole control over the matrimonial home. Mrs. Ashford, you have a deadline of 72 hours to vacate the premises under supervision. Hugh Preston began to protest. Judge Carver interrupted him with a glance. Additionally, I'm designating an impartial forensic accountant to scrutinize all marital finances. This report will be presented in court within 2 months. Any effort by either party to relocate, conceal, or squander assets during this period will face penalties. Is my position understood? Yes, Your Honor, Dalton replied. Hugh gave a rigid nod. Mrs. Ashford, Judge Carver stated, I recommend you fully comply with the discovery process. This court regards financial fraud and divorce proceedings gravely. We will reconvene in 60 days for a status conference. She struck her gavel. Brielle attempted to speak to me in the hallway beyond the courtroom. Connor, please, Dalton intervened between us. Mrs. Ashford, you must stop. All communication passes through counsel. I merely wish to clarify. There's no need for explanation beyond what's found in the evidence. In a low tone, it was my first direct conversation with her in over a week. She seemed to regard me as a stranger. Do you truly believe I'm some sort of monster? She asked. You've led yourself to assume I'm this villain, I replied. I harbor no thoughts. I departed before she could respond. The subsequent 60 days were marked by procedural combat. Hugh Preston contested the demand for forensic accounting, arguing it was intrusive and redundant. Judge Carver dismissed his appeal. Brielle submitted incomplete financial statements, lacking documents that Gerald had previously located. Dalton filed a motion to enforce compliance. The judge concurred and cautioned Brielle about potential penalties. Troy's civil lawsuit was amicably resolved. His lawyer negotiated a reimbursement payment of $67,500, which included his share of the property purchase and damages. Troy transferred his BT Holdings ownership and consented to disbanding the LLC. He also resigned from our consulting firm, selling his partnership interest at a reduced price. I didn't communicate with him during the negotiations. I had no words. The dissolution of our business partnership was more painful than the end of my marriage, if I'm being truthful. I confided in Troy about my company's future. We had constructed something together. Brielle shattered our marriage, but Troy destroyed a deeper bond. The final conference for the settlement took place on a Tuesday in April. At this point, the independent forensic accountant had already submitted his report, which validated Gerald's findings and uncovered an extra $8,700 of dissipated funds we'd overlooked, amounting to a total of $79,000 in marital assets stolen by Brielle. Hugh Preston entered the conference room looking dejected. My client is ready to settle, he stated without delay. Dalton remained unresponsive. Terms? Mrs. Ashford will consent to an inequitable division of assets considering the dissipated funds. She'll transfer her portion of the Asheville property to Mr. Ashford. Without seeking repayment, she'll take on all debt incurred under her individual name, including credit cards, and waive spousal support. In return, Dalton requested, she seeks to avoid criminal fraud charges. This took me aback. I looked at Dalton. We haven't initiated criminal charges, Dalton clarified. However you could, Hugh countered. The client acknowledges that her actions amounted to financial misconduct. She is prepared to repay everything owed to avoid criminal charges. Dalton looked at me. It's your decision. I pondered, deeply pondered. Brielle had deceived me, embezzled funds from me, and lied for 18 months. Her intention was to surprise me with divorce papers while concealing assets and safeguarding her partner in an affair. Facing the consequences is necessary, but criminal prosecution would involve years of my life spent in courtrooms recounting the betrayal. It would entail headlines, public records, and explaining to potential partners why my former spouse was accused of fraud. I want full restitution. She should return every cent taken, pay legal fees, and provide a lump sum for emotional distress and the time invested in cleaning up her mess. Furthermore, I demanded in writing that she admits to the dissipation, with no opportunity for reinterpretation as a mutual misunderstanding later. Hugh nodded slowly. We can reach an agreement on those terms. And one more thing, I added. Hugh gazed at the dogs, his Goldens, affirming they were his unwaveringly. Connor be rationalized, Hugh suggested. Those are my conditions, I stated unequivocally. Either she accepts or we proceed to trial, making clear to a jury how she financed a vacation condo with stolen marital funds through her affair partner. Brielle, sitting white and quiet in the room's corner, nodded. We agree, Hugh said. The divorce was finalized 6 weeks later. I didn't attend the closing hearing. Dalton represented me instead, with the judge signing the decree. In the end, Brielle received 35% of the shared assets following settlement calculations. I retained the house, dogs, business, and a 3-year payment plan for her reimbursement. I sold the Asheville condo within a month, earning $195,000 from it, profited from her betrayal with a somber sense of satisfaction. Subsequently, I revamped the consulting firm, introduced a fresh collaborator, a woman named Vanessa, who had experience in strategic development for a Fortune 500 corporation. The enterprise has gained strength since Troy's departure, 6 months after the divorce was finalized. Brielle then sent me an unmediated letter. A personally penned note was delivered to my office. I almost discarded it. However, curiosity prevailed. The letter spanned 3 pages. She expressed remorse, not in a vague, self-centered manner meant to seek forgiveness, but genuinely taking accountability. She elucidated that she had been discontent for years, felt neglected in our marriage, believing I wouldn't mind her departure because of my constant work commitments. She confessed that the affair began as a quest for emotional validation, which spiraled into something she couldn't manage. She stated that the financial fraud occurred gradually, through small justifications that escalated to felony-level theft. She disclosed that she had been attending therapy, striving to comprehend why she wrecked our lives. The letter concluded with, "You deserved more than what I provided. I wish you well." I read it twice before tucking it away in a box alongside other divorce papers. I did not reply. People often ask if I'm still angry. Truthfully, I am no longer so. During the investigative phase, when I discovered the extent of the deceit, I was indeed enraged. During the property settlement talks, Hugh attempted to downplay Brielle's misdeeds, causing me to feel furious then. However, more than a year and a half later, I mostly feel liberated. I'm no longer in a union where I scrutinize bank statements or speculate about my partner's whereabouts. I'm no longer maintaining the facade of a harmonious relationship while someone tears it apart. I'm not acting the part of the unaware spouse while my partner and business associate deride me. I am now free, the house is peaceful now, and even the dogs have adapted. I've resumed dating casually, no major commitments yet, enjoying evenings and talks with individuals free of the burden of 18 years' worth of pent-up resentment. Work is improving, too. The client base has expanded by 40% under Vanessa and my leadership, making the workplace feel more collaborative rather than tense. I often ponder over ways I could have acted differently. If I had been more engaged, more mindful, perhaps Brielle still would have betrayed me, still stolen, but possibly not. However, I am certain that I did not induce her actions, did not push her to open secret credit cards or purchase property with another man, nor did I deceive me for 18 months. She was the one who did all that, And when I uncovered it, I didn't crumble, plead, or make desperate efforts to salvage a marriage that had already ceased to exist. Instead, I gathered evidence, prepared, and acted accordingly. Contrary to what she predicted, I have moved on, am not broken without her. I departed without her realizing it, submitting documents as she prepared an ambush, exiting the courtroom with what truly mattered, my dignity, business, dogs, and future. By the time she comprehended the situation, I had already moved forward, remaining in the same position all along. She believed she was engineering my collapse. Instead, she was recording her own demise.